Brigadier, thank you, and good morning to you.
Good morning to everyone.
Thanks. Now, you made mention of the fact that, remember yesterday I said when you spoke about the presentation that you made to the office of the DPP, it would have been something that would have happened in the boardroom. You guys sitting around the table and you making an exposition of the investigation, and then you said, no, it was in the form of a memorandum, not so.
Babingelela ke fakazi bathi ukhumbula khona njalo izolo ngesikhathi kade ummeli akhuluma ngodaba noma ngesikhathi bekakubuza ngodaba lwepresentation ukuthi ngabe mhlawumbe ke kade nihleli kanjani ukuthi umhlangano wehlezi mhlawumbe kutafula kade nihlezi khona ke lapho ke bese wena kwabatshela malana nalokhu kade unako ke bese wathi wena cha kade kungasenjalo ke lapho ke kade wena ubhalile uhlelo balwiza ukuthi memorandum.
That is correct, my lord.
Athi yebo kuyiqiniso lokho.
Now, thank you, Brigadier. Now, what was the factual, what were the facts that you presented in that memorandum on which you requested the state to make their decision on?
We don't mean to interfere with my colleague's cross-examination, but yesterday at length he canvassed this issue, which in our view, it's irrelevant. And secondly, my lord, what happened when Brigadier Gininda briefed the office of the DPP, it's irrelevant. It's a collateral issue, my lord, that we submit in our view should not be canvassed during these proceedings. It's like what happens during consultation, it remains there, my lord. It shouldn't be brought into the courtroom.
That is misinformed, my lord. Remember that briefing or that memorandum is the basis why this trial is happening. So there's nothing secret about it. It could have formed the basis why these accused persons were ultimately arrested and charged with the offenses that they were charged with today. So there's nothing irrelevant on that. Yes. We are entitled as a defense, and more particularly these accused persons are entitled to know what were the facts upon which the state decided to indict them to come and stand trial before this court. What is wrong with that? They are entitled to. Unless there's something which is being hidden.
Dr. Zibana just reminded me, my lord, that the late Mr. Mgomezulu made Brigadier Gininda to read through his affidavit on which the application for a warrant of arrest was based. So the information is already before court, my lord.
My lord, I'm not talking affidavit here. I'm talking the factual basis upon which the state decided to arraign these accused persons to come and appear here. I don't know what was contained in that memorandum. All that I want to get from this witness, who is the lead investigator on this court, what is it that, what were the facts that he laid before the state on which he requested the state to make a decision on, which later on then the state indeed took a decision to arraign these people, this accused person, to come and appear here before court. There's nothing untoward.
Yes, sir.
Thank you.
Manje ke kade bebuza ke ummelweni bamnumzana ukuthi kahle kahle ngabe malana nodaba lomhlangano lethimba labashushisi futhi nethimba lawo labaseshi becala ukuthi kade kuyini le amaphuzu wabo kade badigida ke lapho ke lomhlangano waphathe benawo noma yini amaphuzu kade bekhuluma ngawo ke ngesikhathi kade benomhlangano.
Before you start, Brigadier, I'm going to request you to take it point by point, because I'll also be taking notes here. I'll be very wary if I were to hear you saying something very, 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 very long, which I will end up being confused and coming back to you. What is it that you are saying there? Just take it point by point up until then you say, no, yeah, I'm done. Do you understand, sir?
Bacela-ke kufakaza ukuthi uma ngaba akhuluma ke anciphise inkulumo yakhe ke asho uphuzu lokuqala-ke bese anikeze ummeli isikhathi sokuthi abhale phansi ngoba akafuni ukuthi ummeli ufakazi akhulume inkulumo eningi noma udaba olude bese akhohlwa ukuthi bekakhulume ini ufakazi bese futhi abuye futhi ambuze ukuthi konje kade buthizeni qala.
I do understand, my lord, but obviously the difficulty I may have, I will try to summarize because I don't have the memorandum with me, and that was done in 2020. But I do have a recollection of what it contains. So insofar as what it contains, I will go slowly so that Advocate Niti can write and take notes. But,
Yes.
but it will be a summary of what I recall, and I'll refer to those points, my lord.
Athi akasakhumbuli kahle kahle ukuthi umhlangano lo kade uqukethe ini noma amaphuzu omhlangano kade bequkethe ini konake noma kade kuyini amaphuzu kade ekhona ke ngaphakathi kwememorandum yakhe kepha-ke lapho-ke uyoza ukuthi anciphise mayelana nenkulumo leke ngoba lokho kwenzeka esikhathini seminyaka eminingi edluleke ngomnyaka ka-2020.
Now, my recollection, my lord, is that in the memorandum, you first indicate the background of the case, what transpired. Example, now you'll refer to the incident that took place on the 26th of October. So it's a summary of what happened in the case. You summarize those facts. And that's what I did.
Athi kokuqala-ke lapho-ke kwenza-ke isikhangiso-ke secala leli lonkana ukuthi ngabe kahle yini eyenzeka mayelana necala leli futhi ngabe icala leli lenzeka ngaliphi-ke ilanga bese wakhuluma ilanga lange-26 zaka-October ngomnyaka ka-2014.
And then you indicate as to where the investigation led me to, and specifically led me to accuse 1, 2, 3, 4, 5, my lord, before court.
Bese lapho-ke yabhala ukuthi usearch kwicala ngesikhathi buphenya icala waqala kuphi-ke lapho-ke futhi maqeda lapho-ke bese wahamba waya kumsolo wokuqala umsolo wesibili umsolo wesithathu wesine futhi nowesihlanu nokuthi yini yamkhokhela thizeni athole abasola.
I will then, under accuse number 1, my lord, indicate the evidence that we have collected at that stage that was contained in the docket that will talk to confession statements that were made by witnesses that we had at the time, under accuse number 1.
Futhi athi ngaphansi komsolo wokuqala-ke lapho-ke kunodaba lwey'tetimende-ke zofakazi kade beyitholile futhi nodaba lama-confessions mayelana naye ngokuqondile noma ngokukhethekile.
Just a second. Thank you.
The same exercise, my lord, will be embarked upon when it comes to accused number 2, 3, 4, and 5. So under each and every accused name, I will indicate the evidence that was collected under that accused that we have that connects that accused to the case. So the same principle was applied with accused 1, 2, 3, 4, 5. In other words, we'll have accused 1, evidence that connects him to the case under him, accused 2, right up to accused number 5, my lord.
Athi lapho kade benofakazi-ke obukhethekile noma ufakazi lobo ufakazi kade bobaxhumanisa-ke nomsola wokuqala futhi uhlelo lwabo balenza kubo bonkana-ke abasola ngesikhathi kade benofakazi kade benabo-ke lapho-ke.
I'm sorry, Brigadier. Those are not facts. I'm going to request the court that if needs be, you go get your memorandum that you submitted to the DPP and then it be made available to us and then we work on it. Because now I don't know what evidence are you saying you had in respect of accused number 1. I don't know what evidence you're saying you had in respect of number 2. But then you're saying that is then the process that I also embarked upon. I want facts, which you presented to the state.
Athi lapho-ke akazwisisi kahle-ke mnumzana njengofakazi ukuthi ngabe kahle yini le kade unayo-ke mayelana noma amaphuzu ofakazi kade unawo-ke mayelana nomsola wokuqala futhi nomsola wesibili uma ngabe uthi-ke nina-ke nenza-ke uhlelo olufanayo ncamashi noma uhlelo olulodwa ngesikhathi kade nebathwesa amacala noma ngesikhathi kade nephenya icala.
Issues such as the memorandum or the summary of the case by the investigating officer are filed in the B section of the docket and are privileged. They've got nothing to do with the information that is contained in the A section of the docket. We submit, therefore, my lord, that the defense is not entitled to, not that there's anything to hide in the memorandum, just the issue of legal principle. They are not entitled to information or documents that are filed in the B section of the docket. But secondly, and more importantly, counsel says he wants facts. The facts have been presented before court by way of affidavits. We submit that it is therefore unfair to expect of this witness now to regurgitate facts that have already been presented before court.
Is it please the court, madam? I think probably it eludes the state's attention or mind that I'm doing cross-examination on behalf of accused number 1. I am his new counsel. I don't know what facts were presented here on record, which is the reason why that witness is there to assist me, to assist the court. But again, I emphasize, my lord, there is nothing privileged where an investigating officer prepares a memorandum and says to the prosecutor, on the basis of this memorandum, can you please make a decision on whether you want to prosecute or you don't want to prosecute this accused person? What is privileged about that?
You know what? Have you read? Is it section 279 or 179? Listen. Which makes Batohi.
It's 179.
Batohi decide whether to pursue a prosecution or not.
Yes.
So this witness can help us because that evidence played itself in court here. Which evidence was read to, it was Johnson. Who was the guy then? The guy used to call Sean the Shipman. What's his name?
It's Sean Abrams.
Is that the one who decided?
No, it is the current NDPP.
Oh, Batohi.
Yes.
Yeah, fine. So Batohi goes over that evidence, and the decision is his, not this gentleman.
No, but look, maybe
just
thank you.
And it's a misnomer to say the state doesn't have privileged information. What this witness discusses with Batohi is privileged. The same thing as what you discuss with your witness is privileged. And that is the law.
My lord, I am saying the basis, the facts that he submits to the DPP or to the NPA and requests them to make a decision on, we are entitled to know that. And that is exactly what I'm requesting this week. And my lord, let us for a moment assume that that is privileged. He said he submitted, he made the presentation to the NPA and requested NPA to make a decision on. He did this, in this instance, he did that in the form of a memorandum. I'm simply requesting him to tell me the facts that he presented to the NPA, which facts have got to do with these accused persons that are before court here. They are entitled to know what is it that Glinda told the NPA about us, which ultimately the NPA then decided that we should be arraigned for trial here.
Okay, let's hear you. I mean, I also waste time. Let's hear Glinda.
Maybe just one aspect, if I may be so presumptuous as just to mention that, to respond to one aspect. Counsel says he wants to know the facts on which the decision to charge the accused was based. That decision was based on facts contained in the dockets. And he has been furnished with copies of the statements, copies of the docket on which the information to charge the accused was premised. Nothing more, nothing less, my lord. He already sits with the information. I cannot fathom why he would want a summary that an investigating officer makes for himself and for the purpose of briefing the DPP that he should have sight of that when he's sitting with the statements on which the decision to charge the accused was based.
Yeah, okay.
As it is the court, my lord. It is so that we have a docket, but there is nothing wrong in me while serving that docket to request this witness to give that factual basis or to give the facts on which he approached the NPA. This is cross-examination. The state cannot simply assume.
You know what, I'm going to overrule you. I just read 179. Just read 179.
Then I'm not going to proceed here.
Just read 179.
Well, the heading says prosecuting authority, section 179, subsection 1.
Yes.
There is a single national prosecuting authority in the Republic, structured in terms of an act of parliament and consisting of a national director of public prosecutions who is the head of the prosecuting authority and is appointed by the president as head of the national executive, and B, directors of public prosecutions and prosecutors as determined by an act of parliament, subsection 2. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. I think that's what the court has just referred to. Subsection 3, national legislation must ensure that the Director of Public Prosecutions, subsection A, are appropriately qualified, B, are responsible for prosecutions in specific jurisdictions, subject to subsection 5. Then subsection 4, national legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. Subsection 5, the National Director of Public Prosecutions, A, must determine with the concurrence of the cabinet member responsible for the administration of justice and after consulting the directors of public prosecutions, prosecution policy, which must be observed in the prosecution process. B, must issue policy directives which must be observed in the prosecution process. C, may intervene in the prosecution process when policy directives are not complied with. And D, must review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified in the National Director of Public Prosecutions from the following: Roman figure 1, the accused person, Roman figure 2, the complainant, Roman figure 3, any other person or party whom the National Director considers to be relevant. Subsection 6, the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. And lastly, subsection 7, all other matters concerning the prosecuting authority must be determined by national legislation. That is the sum total of section 179.
You can answer that if you think you can. But what the law says, there has got to be litis constantatio before a person can be charged in a court of law. In other words, the accused himself must plead. And when he pleads not guilty, then that is the commencement of the case. And if the accused or his counselors believe that these charges are frivolous or they are brought for a malevolent reason, then it brings an application to court for the judge to decide whether in fact there is evidence prima facie evidence upon which a person may be charged. So even Batohi doesn't just read. He inspects the docket, he goes to the law, because this is what guides him. And only after that does he charge a person. And the law specifically says a director of prosecutions may not charge a person if there is no sufficient compelling reason. Okay, you can answer Mr. Nisi, if you are able to. That's what the law says.
May I just assist the court, my lord?
No, you don't assist me, please. I've told you what the law is. Don't assist me.
No, I'm
If
not.
I'm wrong, take me on appeal, take me on review, fine. But I'm saying this witness, you can cross-examine him on that very aspect.
Thank you, my lord. Thank you. Thank you, Brigadier. I said I'm requesting the facts that you presented to the Office of the Director of Public Prosecutions, on which you are requesting them to make a decision on these accused persons. Thank you. You say, in respect of accused number 1, you had evidence of a confession, you had evidence of a pointing out, you took statements from witnesses, and what else?
Ngiyacela ukuthi azike lapho kakade bekhuluma malana nezomthetho ke ngesikhathi malana nenkulumo kammeli le bayiqhamukisileke bese umnomzana advocate Balo bese wafunda malana nesigaba lesi somthetho esihambisana nalo daba lo kade inkosi enkantolo idikida ke futhi nommelweni ke lapho ke bese inkosi enkantolo athi kulungile ummeli angaqhubeka kuze ke lo mbuzo ke lana ke uyamvumela ke ummelweni ke manje cela ufakazi ke aphendule ke malana nodaba lo kade noma malana amaphuzu la kade anawo ke amaphuzu lawo ke la khona ke amlekelele ekuthizeni bakhona begcina kuthwesa ke umsoro oqala ke icala lapho ke bese wakhuluma ngodaba lo-confession, udaba lwama-statement ofakazi futhi udaba ukuthi kade ikhonjiwe yena ke lapho.
My lord, so with greatest respect, previously, even on the trial, within trial, and subsequently on the trial, when I was busy, particularly under cross-examination, I dealt with the evidence that connects all the accused. And that is found because I was referred to various statements, but the statement which contains the facts, the evidence that I have on each of the accused, I was made to read it in court, and it summarizes all the evidence, and that is A198. That is the application for the warrant of arrest of accused, dated the 23rd of October 2020. Under each accused, the facts, as Advocate Nisi says, it needs the facts of what evidence did I have. That is a summary of it, although I was directing it to the courts, but it was emanating from the docket, not from me, and it is the facts that I presented to the DPP. Now, if I have to be specific as to point by point what is contained, it means I must go through this statement. I've dealt with it.
Go through it again.
Athi-ke lapho-ke phela lo daba lolu-ke ummeli wenu-ke banomzana kabuza ngalo-ke malana nodaba lwamaphuzu lawo kade wona-ke anawo futhi wamikise kwithimba lehlangothi lezabashushisi ekuthizeni abashushisi abakhulu bese bathatha isinqumo-ke lapho-ke sokuthi yebo asibathwese icala lesigameko lesi akade ngisolwa ukuthi nisenzile-ke lapho-ke udaba lolu wakhuluma ngalo-ke la enkantolo ngesikhathi icala ngihlelelwe phansi likhulunywa le nkantolo noma beliqoqala enkantolo futhi wabuya ukhuluma ngalo lo daba lolo ngesikhathi kade bembuza ke imibuzo ngaphakathi ngesikhathi kade kunomzila ngaphakathi komzila noma ngesikhathi kade kunokufuna ngokompikiswano athi khona ke la ngaphambi kwenkantolo ke athi khumbule khona njalo lana ke udaba lolo lukhona ke futhi lokuzana ama-facts lawo ke noma amaphuzu lawo ke wabhalile lana ke ngaphakathi kwedocket ke lapho ke futhi umbhalo wakhona ke noma bawumakhe ngokuthi u-A198 futhi ilanga lakhona ke kade kuyi-23 zenyanga ka-October ngomnyaka ka-2020 ke lapho ke athuma ngabe inkosi enkantolo yamvumela.
Winners on their home turf. Now they face off on the global stage. 32 of the world's greatest.
Okay, my lord, it reads as follows. I, the undersigned, Bongani Nicholas Kenela, state under oath as follows. I'm employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same Act. I am currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit at the National Commissioner's Office with the rank of a colonel. And then it mentions the service number as well as my cell phone number, my lord. Paragraph 2 reads as follows. I'm the lead investigating officer of phosphorus case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 2030 and 2100 hours. The deceased was shot at the house belonging to then his girlfriend, namely Kelly Kumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two blackmails entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the accused was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second accused. The second suspect was described as taller, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Senzo Meyiwa on close range on his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one cellular phone belonging to Ms. Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects were wearing it is also stated that suspicious suspects wearing specific clothing, amongst others a hoodie, were standing hidden away only a few meters from the crime scene prior to the incident taking place, and on their cell phones. It is stated that the suspect fled on foot. The suspects fled on foot, and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identities were compiled through witnesses of these suspects. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 2030 and 2100 hours. The deceased was declared dead on arrival at the hospital on 21/15. Paragraph 3. Investigation revealed that the cell phone which was robbed was picked up through a cell phone towers until the signal was lost, covering the area of phosphorus area. The said cell phone was never recovered to date or even switched on again. The evidence explained hereunder will indicate that the planning of the offense and gathering after incident took place at Phosphorus Hostel. Investigations which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than the robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa.
Thank you, Holy.
Please, let him finish. You asked the question, let him finish.
But my lord, I'm busy taking note as well.
Yeah, but you must say what he said in that affidavit.
But then when I'm going to take
You've got a
notes,
copy, Mr. Minister. You don't have a copy of that affidavit.
I don't have it before me.
Okay, I'll adjourn. Please make a copy for Mr. Minister.
Thank you.
Okay. Please.
I cannot do my cross-examination.
We are back again in this hot court today. Oh my God. Everything is kind of derailing, and the judge is kind of today freaking out. I don't know what is the problem, but there must be something that is being hidden that has triggered the judge and Baloyi to object like nobody's business, because they don't want this memorandum facts to come to light so that everybody must know how these 5 accused were charged in court. So Advocate Mnisi is not backing up. He is not backing up. He wants Brigadier Kininda to read the facts of the memorandum that he presented so that those 5 accused can be charged. Like they have been charged, they are before the judge now. We know everybody is there now. So now what Mnisi is doing, Advocate Wemvula, Advocate Mnisi is really irritating the judge by sticking into that, and he doesn't want to just move an inch. He's keeping it like nobody's business. Whatever the judge tries to do and the prosecutor tries to do, object or whatever he brings up, but Mnisi is nowhere to move an inch to this. So family, what do you think about what Mnisi is doing? Is he right to look for the facts as to how this, because I understand he has done his diligence in finding out during the time when he was trying to prepare himself for this cross-examination for Brigadier Kininda. I think he has everything hidden in front of his chest. He doesn't want to play the cards so that everybody can see what he holds on his cards. So now he's just playing it down because he has the facts, but he was testing the witness if the witness really has the facts as to exactly what happened and how those 5 accused were brought to court to be charged. So now it's before court, and the judge now is freaking out, already freaking out. He's even bringing up, when he freaks out, sometimes he just lose it big time. We know that the judge is not somebody who's always patient. He likes to take things really different from other judges. The way he behaves, his behavior is not a good behavior for a judge who's going to write a judgment for these 5 accused. It's like he has already made his mind as to how he is going to charge these 5 accused. I think in his mind, he feels like they are guilty, but Mnisi is not backing up. He just wants to know that what was in the memorandum that you prepared and you send it to wherever to apply for this 5 accused to be charged. But I think now it's really becoming hard. The judge now has already told Mnisi that, okay, Mnisi Wemvula, you can take me for appeal. I don't care, because it's how he behaves all the time in court. He doesn't, when he feels cornered or he wants to defend somebody that he feels is so close to his heart, then he will always go out and just being a shield and try to shield everything away from that person and take the heat, forgetting that he is compromising, failing to understand that he's compromising his reputation as a judge. Because if you compromise your reputation and it gives a lot of people like open their eyes up and say, who is this judge? I think everybody now will understand the judge's behavior, that he can turn a court in no time to be a tavern. Oh, family, what do you think about this? Please drop your comment, and don't forget to like, share, and subscribe. Ngiyanithanda nonke ngothando lukaLove. Ngithi kini bantu bakithi kumagumba manomhlaba lapho nikhona khona entabeni emifuleni kuphi phakathi eGoli Soweto KZN kwamashu kuphi kophi lapho ngaba khona Pitori Africa Mall. Sithi kini bantu bakithi naphesheya kweyilwandle, sithi ke hayi ke ngomusa sizawuthi nje ukushenqa kancane, and sithi let's keep the fight on. And never forget to like, share, and subscribe. Ngiyanithanda nonke ngothando lukaLove. Ngithi kini bantu bakithi, let's keep the heat on so that we can really help the Meyiwa family find closure as to how their son was deleted, his life was deleted. So family, let's get on it, and please don't forget to pray for Mnisi Wemvula. We know that court it can change to be something else. Let's keep him in prayers wherever we are, whatever we do. Let's not forget to just all the defense lawyers, we keep them in prayer, because there's still a lot that they have to go through. As we all understand that we feel the 5 accused are not the right people who are supposed to be in that dock, but as to how it happens, the truth will come out. Let's keep our fingers crossed. Bravo, bravo, bravo.